Hi everyone, Samantha Fitzgerald with SJF Law Group. Today we are talking about two topics that go very well hand in hand with one another: procrastination and estate planning. LegalZoom says that only about 33% of the population has any form of estate planning done. That's probably accurate in my opinion. That's probably about what we see. So why do people procrastinate doing their estate planning? So some of the things that I've seen is people don't want to talk about it. They don't want to think about it even. Sometimes people think if they do their planning or they talk about it, something bad is going to happen. It could be cultural. We see people from other countries are less likely to want to talk about these things sometimes. Some people might think it's too expensive, so they just automatically don't even try to do it. Sometimes people are not sure who to appoint in the different roles of authority or who to give their money and their assets to. So instead, they just choose to do nothing. I think sometimes people think they don't have an estate, that they aren't wealthy enough to even need estate planning. And then some people just don't even understand what the term means. They don't even understand what estate planning is, and they don't think they need it. So that is not the case at all. As soon as you are 18 years of age, you should have some form of estate planning in place. It could be something minor, but you need to have something. So what happens when you procrastinate and you don't have these documents in place and something happens? So I'm going to kind of walk through each of the four main documents and give a little example of what could happen. So the first one we're going to call a health care surrogate designation. These are called different things in different states. Some places call them a medical power of attorney. Here in Florida, we call it a healthcare surrogate designation. And this is where you designate somebody to make medical decisions for you if you're unable to make your own decisions. Oftentimes in here, there is also something that's called a HIPAA release, which is an authorization to allow your medical professionals to speak to somebody on your behalf. So what happens if you don't have a healthcare surrogate designation or a HIPAA release? First of all, nobody has any access to your medical information whatsoever because of the federal HIPAA privacy laws. Now, that could be your 18-year-old child that just went off to college. You have no access to any information if they are injured or hurt or sick and they're in the hospital or some sort of medical facility. Legally, nobody should speak to you. So that's not good. So right there, you turn 18, you need to have a healthcare surrogate in place. But for real adults, as we call them, what happens if you're incapacitated and you don't have a healthcare surrogate? So it could be very ugly if multiple people have the same level of authority to make decisions for you and don't agree. So it could be that you are not married, so you don't have a spouse, but you have several children and they don't get along or they don't agree. Or you don't have children, but you have parents and your parents don't agree or get along. Obviously, that can cause a lot of problematic scenarios. If you are sick or hurt, you need medical attention, you need an operation, you need a treatment, something like that. You certainly don't want people fighting under those circumstances. It might also be that you have somebody making decisions for you that you simply don't want to make decisions for you. So you have the wrong person making decisions. Then we've got the power of attorney, which is for financial decisions. So here, it's even worse because if you don't have a durable power of attorney in place and you are incapacitated, nobody has any access to pay your bills or make financial decisions for you. In that case, you might end up needing a court-appointed guardian. So the healthcare surrogate and the durable power of attorney, those two things together can help you avoid a very costly, time-consuming, and invasive guardianship proceeding. And then there's your will and your trust. So without having any estate planning documents in place that dispose of your assets upon death, your estate may end up going through the court process through a probate administration. Your beneficiaries may end up fighting with one another. Somebody may inherit assets from your estate that you don't want to inherit assets from your estate. Probate is a very time-consuming, it's a lengthy process. Our courts are severely underfunded. It takes a very long time to get through this process, and a lot of things are out of our control. So this proceeding is different from county to county within the state of Florida. It's different sometimes from judge to judge within the same county. The judge really kind of holds all the cards. Of course, there's a law to follow, but if the judge requires you to get a court order to do something and they restrict the personal representative's powers in some way, then there's not too much we can do about it other than to comply. And that significantly increases the time to get anything done. It increases the cost to go through this process. So if you have difficult assets such as real property or a business that is time sensitive and needs to be sold, or something needs to happen with it, maybe a mortgage needs to be paid, association dues need to be paid, it can be really, really problematic when we have to jump through a lot of hoops in court. One case we had a while back was someone in their 50s, so they didn't think that they needed to do estate planning. They procrastinated, and their estate ended up going to half to their real father instead of to their stepfather that raised him his entire life. A simple will in this situation would have avoided that altogether. So procrastination is not good when it comes to your estate planning. There's not always a tomorrow. People get sick, they get hurt, they die unexpectedly all the time. We've had numerous tragedies just in our state of Florida, and in lots of other states that have been on the news recently. And nobody knows when the time is going to come. It's not just about dying. It's not just about assets. It's also about your incapacity with the healthcare surrogate designation and durable power of attorney. So thank you for listening. I hope that you choose National Procrastination Week to stop procrastinating and get this done. Not only is not doing your documents not good, but failing to review your documents at least every few years is also just as bad, because I have seen the wrong thing happen because documents were in place and they don't expire. They're still valid unless you either revoke them or you update them with new documents. So that can be just as bad. So thanks for listening. I'd love to hear your thoughts in the comments below. And if you're not sure where to get started, we have a really awesome YouTube channel. We have a video on there. It's Estate Planning 101, and it discusses the 4 main documents. So that is a great place to get started. And happy National Procrastination Week.